Qué chistoso, güey, el magistrate decía acá, jamás en mi vida me sentí. Es como en 1000 años de... Bueno, por favor.
Vamos a verificar. I think we're live.
Okay, so I mean, essentially, well, why don't you by the way, let's just wait that 1.5 by 100.
I just want to make sure we show up.
You want me to check in YouTube?
Yeah, please. I don't see it. Oh no, we're live.
Okay. Are we ready?
Yeah, she said we're live.
Okay. Good morning, everyone. Before we begin, I will be reading an opening statement. Today is May 21st, 2025. We are here for the Town of Pembroke Park Special Magistrate hearing, and the time is 9:03. I do thank you for your indulgence. Ladies and gentlemen, welcome and thank you for being here today. Please turn off any cellular telephones to avoid interrupting these proceedings. There are no weapons of any kind permitted in these chambers or anywhere within these facilities. In all issues that may come before the special master, we ask that everyone show mutual respect for one another by listening quietly to each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor or in opposition to a speaker. These are hearings conducted by a special magistrate, the purpose of which is to give any alleged violators the opportunity to contest the officer which resulted in the issuance of a civil violation notice. These hearings are conducted in a quasi-judicial manner, and I am the special magistrate assigned to hear today's cases. My name is Andre McKinney. My responsibility is to and that is to hear cases presented by the code enforcement officers and to hear contradictory arguments presented by the alleged violators. These hearings are open to the public. It is required that all persons who testify as to the facts of the case be placed under oath, including the code enforcement officer. These hearings will not be conducted in accordance with formal rules relating to evidence and witness. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code enforcement officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing relevant to the issue, even though that matter was not covered in the direct examination, to impeach any witness, regardless of which party first called him or her to testify, and to rebut the evidence against him or her. It is my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a special magistrate are limited to whether the alleged violation occurred, and if so, whether the person named in the civil violation notice can be held responsible for that violation. I may also modify the decision of the code enforcement officer as to the time contained in the civil violation notice, even though said time is rebuttably presumed to have been, reasonable. I have the authority to assess and order the payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find there is substantial, competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will specify the amount of the civil penalty, the administrative cost of the hearing of not less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. An aggrieved party, including the town, may appeal a final order of the special master to the Circuit Court of Appeals. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record created before the special magistrate. An appeal shall be filed within 30 calendar days of the issuance of the order sought to be overturned. If you are found guilty of a civil violation as charged, you will be assessed an administrative fee of $100. The city representative will present their case first. The alleged violator will present their case thereafter. I will consider the evidence and render a decision after all arguments are heard. At this time, I kindly ask those who are able to stand to please stand and raise your right hand so you can be sworn in. If you intend on testifying today, do you swear and affirm that the testimony you'll provide will be the truth and nothing but the truth? Say, I do.
I do.
Thank you. You may be seated. You've only got one attorney?
Yeah.
Okay. Got one more person. Yes, I see a lot of familiar faces. I just don't remember names.
I don't remember his case number.
Okay, we may begin with a roll call. Joseline Ramirez, Chief Co-Compliance Officer.
Brian Sherman, Assistant Attorney.
Andre McKinney, Special Magistrate.
Aymara Fontalva, Code Compliance Clerk.
Nasli Cardona, BTR Specialist.
And item number 4, we have the adoption of minutes for August 16, 2025 and March 19, 2025.
Is the town moving as presented?
Yes.
Okay, so moved, entered in the record.
Okay. Item number 5, adoptions of agenda, deferrals, additions, and modifications. We have item 5.1, case 9484, added to the agenda to abate fine. Item 5.2, case 9485, added to agenda to abate fine. 5.3, case 9501, added to agenda to abate fine. 5.4, case 9071, removed from agenda, respondent complied before hearing date. 5.5, case 9156, removed from agenda, respondent complied before hearing date. Item 5.6, case 9989, removed from the agenda, respondent complied before hearing date. Item 5.7, case 10414, removed from agenda, respondent complied before hearing date. Item 5.8, case 10571, removed from the agenda, respondent complied before hearing date. Item 5.9, case 5487, removed from item 9.1 to confirm fine and added to item 8.1 for an extension of time. Item 5.10, case 7382, removed from item 9.4 to confirm fine and added to item 8.2 for an extension of time. Item 5.11, case 8279, removed from item 9.7 to confirm fine and added to item 8.3 for an extension of time.
Okay,
And that concludes the modifications.
deferrals, additions, and modifications are so accepted.
Okay, and I believe we only have one attorney present at this time. Is there another attorney besides Mr. Sher? Okay, so we'll begin with those two cases. Okay, that is on section 9.8 of the agenda, case 8288. Chief Co-Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 8288. Property owner Pembroke Crown LLC, site address 2649 South Park Lane, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail, April 25th, 2025, posted to the property May 8, 2025, posted to Town Hall May 9, 2025. It is the town's motion to confirm the fine of $177,100. The property is still not in compliance. They still require one more item to be corrected, which is the electrical permit on the property. Once they do that, then they'll be in compliance. But they did comply with 5 of the violations on the listed notice of violation. Do you want me to present the other case or do you want to go one by one?
Yeah, if there's no objection, we'll present the second case, and then we'll take your response in sequential order.
No objection.
Okay.
Okay. The next case on 9.6 of the agenda, case 7734. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 7734. Property owner Pembroke Crown LLC, site address 2565 South Park Lane, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail April 25th, posted to the property May 8, 2025, and posted to Town Hall May 9, 2025. It is the town's motion to confirm the fine of $374,100. The property is still not in compliance, and what they need to do is the tenant needs to obtain their business tax receipt. They are working on it. However, they still have not had an issued BTR or certificate of use. Okay.
Good morning.
Good morning, Special Magistrate. Thank you, Code Director
Good morning.
and City Attorney Jeremy Shear on behalf of the property owner. So for case 8288, as the Code Director mentioned, this is 2649 South Park Lane.
Kindly, Attorney Shear, just for the record, state your name, your appearance, so that,
Yes, Jeremy Shear.
okay.
Yeah, so the initial violation was for operating without a BTR, outdoor storage, electrical work done without a permit, and having a mezzanine without a permit. My client removed the mezzanine, new racks have been installed, window sign is gone. Just to note, there was never any outdoor storage. It was just a tenant parking a scooter there in the past when he was cleaning it, no longer does so. And as the Code Director mentioned, it's just the electrical work that's remaining to be done. So we're making very good progress. However, one of the main issues is that I believe, and perhaps we could get some clarification, but I believe that there's a request from the fire department to install an internal fire corridor. Can we get some clarification on that for this property?
I'm not aware, but as I mentioned earlier, the only thing pending to correct this violation is the electrical work that the previous tenant did without permits. Once that's corrected, I can close this violation.
Okay, so it seems like we're very close then.
The electrical permit has been written and pulled when we did the clean out on the we got a whole new permit and everything as far as electrical, mechanical, everything is in the operation. But the problem is that we haven't been able to get our own way with this fire thing on all of the cases.
Okay. All right, so I mean, seems like we're almost there. We would ask the town to work with us, obviously, when we get to the point of mitigation. On to the next case, which is more complicated. In case 7734, this is 2565 South Park Lane, relates to the operation of a business on site without a BTR and certificate of use. So just a little historical background. This property had a BTR every year until 2022 when one of the owners passed away. And then the town required the business to apply for a new BTR. And it was denied for lack of a life safety plan because, these buildings were built in the 1960s prior to, multiple amendments to the Florida Building Code. Obviously it doesn't mean current Florida Building Code, but they should be considered legal nonconforming. But that brings me to the next point, which is that the town lost all of its records. So it's impossible to establish that these buildings are actually legal nonconforming. So, number one, we would ask that the town work with us in recognition of the fact that, by no fault of my clients, we can't establish that it's legal nonconforming. We would like to present evidence, photographs and other documentation, to prove that. But nonetheless, my client in the past 2 years has hired multiple architects. The first architect actually left because he said we just can't actually get it done. Civil engineer, and even a retired fire marshal to expedite the matter. Almost everything is complied except for one item, which is the requirement by the fire department to install an internal fire corridor. That would result in a loss of 25% of the space and essentially render the economic value of the property to nil. Like my client will not be able to rent out his space if that happens. There is no other option. I actually reached out to the owner of the trailer park homes behind my client's property and discussed it with him to see if there was a possibility of installing, another ingress egress at the rear of the property. But that's probably not going to be feasible because these are zero lot line properties. That's a residential property, so it'd be going to somebody's, backyard essentially. So, that's pretty much going to be ruled out. So, right now it seems like we're stuck. We would ask the town to work with us to figure out a practical solution, so that my client can continue operating. He's a good, corporate citizen in the city. And, otherwise you're essentially removing all the value of the property. He will not be able to rent it out. So just some recognition of the fact, of the facts of the case here. And I believe that my client also wants to say a couple words as well.
Attorney Scher, I have a question to you.
Sure.
Have you submitted any documents in support of the challenges for this particular case, case number 7734? Have you submitted anything to the town, the building department, zoning, the town attorney? What efforts have there been with regards to advancing the setbacks or roadblocks your client is having with regards to this case?
Right. So in regards to the one, pending issue of the internal fire corridor, my client actually blew up the proposed plan that the new architect had drafted. We can show it to you. Obviously, we can't enter it into the record, but, just for visual purposes, he'd like to show you.
Well, it's in the record with the permits. I would imagine you should have that, but I just blew it up so we can get an idea as to what the problem is. We're at 2649. What are we on?
No.
This is 7734.
2565.
It's been the problem that's going on for almost 2 years now. And again, as he said, we brought in, can I come a little closer?
Yes, you.
We brought in multiple professionals over the course of the 2 years. And if you're saying, what did we give the court or the town? We kept on giving them plans. Can we do this? Can we do this? Can we do this? And we've been shot down in every single way. Now, this is the idea of what the last plan is, but look at what it's doing to the property. This is a 50-foot mark. They want us to continue this corridor for the 50-foot. That means we use 25% of this. This is warehousing where it's supposed to be 10%.
And what's the date on that plan? I'm just curious.
Right there.
Couple weeks ago, right, Tony?
This is, again, a revised plan. This is not the, we put this in a long time ago, but this continues to change over and over again to try to accommodate the town. Actually, not the town, the fire marshal. Okay, but this is what's gonna happen here. 50% in depth into the property. This is the bay, 25 by 100. So now we have to build a corridor all the way from here to here. Now, this is actually supposed to be a 10% office relative to 2,500 square feet. That's 250 feet. So that would be this room right here. Now we're having to go all through this and go all the way to here. Now, this is not the only one. It's every single one. And this is where we're getting stuck every single time. We're trying to put a permit in. We're trying to finalize this. And we already lost 4 tenants by telling them, okay, we have to do this. You came, you saw it, they're empty. Okay, so I can't rent it to a warehouse guy if he's looking for warehouse, and I have to put, let me see, it's about 700 feet of warehouse, office space. They don't need office, they need warehouse. That's what this was built for. So we were trying to go back and forth for all this time with multiple professionals, and we had no luck. Here, this is the final one, the last one. We actually went to the owner of the property behind to see if we could just open an exit door. And it's property on the property, and we've had surveys, we've had, engineers see what can be done. We tried to go from one unit to the next one, even open a door in the middle. That didn't work either. All these plans were drawn out, and again, every time we do a plan, it's $5,000 or $6,000.
Can you just go back into the mic, please?
Yeah.
Just to make sure we have everything on record.
So it's just a tremendous hardship. We can't get out of our own way. We can't get the permit here. We've had this permit here for almost a year or 8 months. I don't know how long, how many times it's going back and forth, and it's not finalizing. So we put this one in now. and we still don't have an answer, okay? And the same thing with 2565. It's the other bay. And I don't know. We don't know what to do. How do we get out of our own way so we can close this? They approved the electrical, they approved the mechanical, they approved everything. The only thing is fire. And every turn of the way, we get stuck with the same issue. So we're trying, but, you know, we're giving up 25% of the property in order to have a corridor. Now, I've already drawn it out. I've conceded to the fact that we're going to have to do it. But look at the hardship it's causing. We lost the 4 tenants, and, you know, we have violations that we're looking at because we can't get out of our own way. It's not like we haven't tried. Jocelyn has been back and forth. She sees we're trying, we're working, we're doing. But it's not finalizing. It's not going anywhere.
No, I understand, and I accept the representations and the testimony of the, for lack of a better word, the quandary with regards to the procurement of the BTR since the passing of the prior owner. But in looking at the procedural history, we're in 2025. The record reflects that the original notice of violation was back in 2022. Hence my question with regards to Attorney Scheer, at what point in time did you or your client advance the roadblocks with regards to and the hardship, using his words, because now we're before the magistrate and a violation does exist, and so
So I think the answer to that question, and it's a good question, is reflected in the permit history. You know, my client has submitted multiple plans which have been rejected over the course of 2 years. He's lost an architect who basically threw up his hands and said, I can't do this. There's nothing to do. Had to hire a new architect, brought in a retired fire marshal to review the buildings, review the plans. And, you know, right now it just seems like we're stuck. So, you know, we do need some sort of compromise to work with the town to figure out what's a way that, you know, we can actually obtain the permits, cure the violations, but not destroy the economic value of my client's properties.
and I'm sure you understand that question isn't answered here, and everything. And so the case is here for confirmation of the fines. What I can say is that in oral pronouncement, I am going to confirm the fines. However, I would strongly urge you to reach out to the town's representatives and put forth the additional due diligence that you appear to have done in getting a resolution ultimately, because a BTR is required. The substantive issue you're having doesn't get resolved here.
Where do we resolve it?
Well,
We've spoken to everybody we could possibly. I had the city manager come to our office, sit down with us and discuss it. You know what? He never came back. He never answered us. He never even responded with a, sorry, we can't help you. Zero. After a meeting with the Chandler, is that his name?
I think so.
You know, that's like disrespectful to our community, actually. He came, he sat, he was very nice. But when he left, thinking that he may come back with some answers, zero. Not even a callback, which is insulting. We've spoken to the attorneys prior to the other city managers, JC or CJ, and the building inspectors. Everyone we could talk to, we talked to. Everybody says the same thing. We can't help you. This is fire. Now, the fire is in this building. The fire is under control of this building. Any way you cut it, slice it, they go and they deny, and it takes another 3 months before we rechange the plans. And then they deny again, and they're doing it to us in 2099. How many times did they deny? 2 years we've been trying to get that permit closed.
Ms. McKinney, if I may.
yes, you may.
Thank you. You know, understanding that at least you've made the oral pronouncement on or about to, or made a ruling on these particular cases. For the record, that I will add, as Mr. Scheer knows, and you're represented by fine counsel, sir, is that the fire marshal was one of a very, very special position in the state of Florida. And understanding that it's nothing on behalf of the town, its employees, or any of its officers, as far as there's the independent authorization for the fire marshal as well as the building official within certain things. So the Florida Fire Prevention Code lays out exactly what their authority is, and as far as if there's any issues with their decisions, how to go about appealing those decisions. At the end of the day, it's nothing that the town can get involved in order to change or sway, and well, we wouldn't do it for you, but for any resident. So, understanding that, sir, but as far as it's within what is the legal ability of the town to do, and what you're asking when it comes to the enforcement and the application of the Florida Fire Prevention Code, the town, any of its employees, its commissioners, elected officials don't have the authority to tell the fire marshal how to interpret the code.
I understand, but I also have to come back and say, you know, we're getting these violations and they're accumulating to hundreds of thousands of dollars while we can't get out of our own way. How do we resolve it?
Well, with regards to the fines, you can apply for abatement. Everything that Attorney Shear and yourself have set forth, once the violation is in compliance, is taken into consideration in the mitigation factor, which is why I asked what efforts, how have you advanced this?
We've done everything possibly that we could think of. I don't know. If we're missing something, tell us.
And that your testimony is accepted. And as the town attorney has indicated, what you're asking for, this is not the forum or the venue to be able to provide a solution or resolve the issue that you are facing with regards to the loss of area footage and complying with the fire marshal regarding life safety in order for the BTR to be issued. Here we're answering really just a simple question for today's hearing, and it's whether the violation is in compliance. And I
Can't finish it. Can't close it. If I can't close it, how can I be compliant?
right, and I understand your testimony.
To all the fire sheriffs and marshals, whoever we could talk to. No compliance, no help. There's no, what the grandfather didn't for this property.
Legal non-conforming.
Legal non-conforming. It just won't do it.
Yeah, I mean, we thought it was important for today to enter, you know, our oral testimony into the record so the town's aware, so that when we do get to that point, hopefully, you know, it'll help our mitigation efforts. But yeah, I mean, right now, you know, we are stuck.
Madam Magistrate, we have the building manager here who would like to
Oh, the building manager, yes.
Jeffrey Lewis, you would like to say a few things about the matter?
I don't think he was sworn in.
Yep.
Okay. Can you raise your right hand? Do you swear and affirm that the testimony you'll provide will be the truth and nothing but the truth?
Yes.
State your name for the record.
Planning on speaking. But,
Yes.
Jeffrey Lewis, building manager for the town of Pembroke Park. For this matter, as you mentioned, you'll need to speak with the fire inspectors in order to have this resolved. We can set up a meeting with the current fire inspector, and then that could escalate through Broward Sheriff's Office Fire Prevention Division in order to figure out the solution.
So we did that already.
Well, let's do it
You
again.
would have to do
Yeah.
it. Correct.
We did it already.
Architect
We'll
is
do it
starting
again.
to file.
Sorry?
We would appreciate if you could initiate that meeting.
Yeah. we
Sorry,
can go ahead
excuse me,
and
Iris
schedule it.
Waters. Our architect is in communication with Kyle, and this is his suggestion. But this is where we're saying we're losing square footage
Understood.
over the suggestion.
That can be spoke about with the Bureau to
Okay.
figure out any other solutions in this. if
Rather
that's-
rather than that.
Okay. Okay, so it looks like the town is assisting with having a meeting to address the substantive issues. And so if there's nothing else by either side, I'll go ahead and give formal oral pronouncement. This is on case number 7734. Is there anything else you'd like to add?
No, thank you. We appreciate the efforts of the town and the building official, and we'll see where the meeting goes with the town and the fire marshal. And hopefully everybody understands, you know, that we need to come to some sort of practical solution here.
Remember, we have probably 15 of these units, 12 maybe. I don't know. They're all in the same issue. Every time somebody leaves, we can't get a BTR.
And hopefully with the meeting that the town is facilitating, a resolution can occur. Okay. And again, as I've indicated, all of the efforts set forth and everything your fine attorney, Attorney Shear, who laid out, can be advanced in the mitigation. And the record is noted that you have shown myself and the town the plans.
Does this mean that it becomes a judgment or anything on the record?
Yeah, but we'll
of the
mitigate.
property? No,
We'll
no,
mitigate.
but is my bank going to see that?
No. Okay. Okay.
I mean, they're gonna
If there's nothing else by either side, based on the testimony
I don't know.
and evidence presented, there is substantial and
When this order goes and enters, where does it show? Doesn't my bank get to see that? As a violation against the property for whatever dollars it is?
well, if the town records it in the public record, yes, anyone can see it if and when it's recorded in the public record.
So that's even more damage for us. You're talking about 300, 200, you're talking about hundreds of thousands of dollars. The bank sees that, they might call my loans back.
I can't speak specifically as to what the bank or their process.
Is there a way that we could possibly, do this without the recording until we come to mitigate it?
That's a question for the city. I don't do recordings.
So,
For fairness and formality, we have to move forward with the imposition of the lien. We already continued this case previously, and these two cases are repeat violations.
well, they're not repeat, they're the same violations that we can't get out of our own way. How many times do we?
As you stated previously, you have other units that have been in the same violation, so they're.
We're talking about this particular two units
Right.
now? How many times do we have to go back?
The
before
state
our-
law says it doesn't matter which location it is, but if it's the same owner with the
Yes.
same violation, it's considered a repeat violation.
And I'm going to give oral pronouncement. Because we're here just to confirm the fines. And Attorney Shear has done a good job with creating a record of the diligence and everything that's set forth. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. To date, the property remains out of compliance. The fines are hereby confirmed. The respondent is ordered to comply and correct the violations. Failure to correct the violation and come into compliance will result in the continued accrual of the per diem fine. The $100 administrative fee is already assessed.
Yes.
Okay. With regards to case number 8288, Attorney Shear, that case is also here for confirmation of the fine. I believe we're at $177,100. You want to go ahead and set forth your position with regards if you want to set forth a record. And of course, your client has the opportunity to be heard on this case.
Yeah, I think we had discussed that. That's the, my client has made great progress on this property. Removed the mezzanine, installing new racks.
Looks like there's one item pending.
Just one item pending, which is the electrical, which to my understanding is in good progress.
Yes.
Right, so
Okay.
hopefully we should have that complied very soon.
Okay, and once it's in compliance, once more, you can apply for the abatement of the fine. If there's nothing else by either side, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. The fines are hereby confirmed. The record reflects to date the property is not in compliance. Respondent is ordered to come into compliance and correct the violation. Failure to correct the violation and come into compliance will result in the continual accrual of the daily per diem fine. And the $100 is also already assessed in this case. Good luck to you.
Can I just say something?
Yes.
On top of it all, the fine continues. The fact that we're here and the fact that we have permits and the fact that we can't get out of our own way because of the city declining, why should that fine continue?
You know, Chapter 162, which is the chapter in Florida statute that governs these proceedings, are set forth. I'm not the legislature. I just follow the law. My First Amendment opinion as to what makes sense is irrelevant. I just follow the law, and that's the way our state legislature has set forth the statutory scheme. But I will say, you have a great attorney. You guys have been here on at least one prior occasion, and so he's put forth the record. It looks like you just have one item remaining in case number 8288, and so I would encourage you to press forward and come into compliance and apply for the abatement. And I'm sure Attorney Shear will submit a great application. on your behalf.
Okay,
Keep your attorney.
thank you.
Please. Just a moment so you can get the order, please.
We can call the next case when you're ready, Officer Ramirez.
Next case on section 8.11 on the agenda, case 9628. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9628, property owner AZURE LLC, site address 2111 John P. Lyons Lane, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail, April 11, 2025. Posted to the property May 8, 2025. Posted to Town Hall May 9, 2025. It is the town's motion to extend the time for 90 days, if not a per diem fine of $250 and a $100 administration fee.
Is there anyone here on this case? Good morning. Yes, come on up. Kindly, in the microphone, state your name for the record and who you are in relation to the subject property.
My name is Marlene Sukdev. I'm the owner of AZURE LLC.
Okay, so it looks like this is a motion to extend.
Yes.
Where it's extended for what, 90 days?
Yes.
90 days. Otherwise, a $250 per diem and $100 assessed. Would you like to add anything, or you're in agreement?
Agreed, yeah.
Okay. Based on the evidence and testimony presented, there is substantial common evidence to approve the request for an extension of time. Respondent is hereby ordered to come into compliance within 90 days. Failure to correct the violation and come into compliance will result in the fines of $250 per day accruing on the property until it's in compliance, and there is a $100 administrative cost assessed. Good luck to you.
Thank you.
You're welcome. It's $250. Okay, thank you. We can call the next case.
Next case on section 10.3 of the agenda. Case 8397. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Case 8397, property owner Timely Property, Inc., site address 3001 West Holland Beach Boulevard, Unit 3112, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail, April 11, 2025, posted to the property May 8, 2025, posted to Town Hall May 9, 2025. It is the town's motion to reduce the fine of $40,100 to $6,100.
Is there anyone here on this case? Come on up for.
Madam Magistrate, it's the same respondent for the section 10.4.
Okay.
Do you want me to present that as well?
Yes, we're going to go ahead and present the second case, and then we'll give you an opportunity to respond to 10.3 and 10.4.
Okay, which one first?
I'll present the other case, and then you'll go, okay? You can stay there. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8403. That's item 10.4 on the agenda. Property owner Timely Property, Inc., site address 3001 West Holland Beach Boulevard, Unit 313, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail, April 11, 2025. Posted to the property May 8, 2025. Posted to Town Hall May 9, 2025. It is the town's motion to reduce the fine of $40,100 to $6,100.
Okay. Okay. If you could kindly state your name for the record, and we will take up case number 8397, which is 10.3 on the agenda.
Okay. Good morning. My name is Joaquin Soler, with Timely Properties.
Okay.
And my name's Leslie Poblete, Timely Property.
Okay. You guys are the owners,
No.
the representatives?
Yes, ma'am.
And you're here with permission of the owner?
Correct.
Okay. If you could speak in the microphone. Okay. So it looks like for case number 10.3, which is, I'm sorry, case number 8397, this is an abatement from 40,100 to 6,100. Okay. Okay. Anything else you'd like to add before I give oral pronouncement?
Yes, is there any consideration of lowering it down?
Well, the town has reduced it by 85%.
Because this is a very small office space, and then the tenant just left right there, you know?
You have to explain what happened.
You wanna give your
Explanation.
yes,
I think the violation was dated April of 2023. Like, they saw a tenant there, but then the tenant left in June of 2023. So it's like every time they just leave. So they couldn't get a BTR by then.
Okay, if I'm understanding what you're saying that when the prior tenant vacated, the owner wasn't able to obtain a new tenant in
Correct.
order to apply
Yeah.
for a BTR.
Correct. But then in like a year, a new tenant came in.
In 2025.
Yeah. And she got a tax license just recently in March. So I'm just asking you if you could lower the fines a little bit,
It was,
you know?
it was vacant for over a year.
Yeah. So there's a new tenant now that has a BTR at that suite number.
Okay. What's the town's position with regards to?
The town's position is we provided multiple notices, also notices of non-compliance. So there was an obligation for them to call and let us know, hey, the tenant left, the violation is cured. However, I didn't get that call until I sent out the notice of confirmation of fine back in February 2025. But before then, we have sent notice of final order. We have sent notice of affidavit of non-compliance. So there's an obligation for the party also to contact the city and let us know what's going on. And that didn't happen until then, until February 27, 2025, that I was able to see that there was nobody present inside the office.
That's correct. I gave her a call like sometime in March. I said there's nobody there. So then she went to the space and looked at it. She was kind enough to look. So it doesn't mean I didn't do anything. I gave her a call.
Right, but what the town is saying, why did you wait so long? And if I'm understanding, you guys are not the owners. You are the manager?
Yeah.
Okay, and you manage this property or space?
Yes.
Okay, so why weren't you in contact with the town?
We have. We called them up.
It was also the tenant didn't call as well. So we have the tenant who's ultimately responsible to get the BTR. There was no communication. They were here, I believe both of them were here when there was a formal hearing. So they knew that they had to correct these violations. After receiving the final order, no communication was done. And then reinspection was done back in February 21. That's when there was a confirmation of fine and a non-compliance affidavit.
Okay, I understand. Part of the responsibility of the person who manages the property is to stay in communication. Now, while the tenant did not obtain a BTR, ultimately, it's the owner's responsibility because it's his or her or the entity's property. And so I'm going to accept your testimony that you were, proceeding to cure the violation. I reduce the fine by $1,000, which would be $5,100. Let me give oral pronouncement. This is on case number 8397. And based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for abatement. Further, from 40,100 down to 6,100, and by request of the respondent, an additional reduction by $1,000, bringing the total abatement to 5,100. You must pay this amount, or the owner, within 30 days, or the original fine amount will resume. Next case is case number 8403. Again, this fine amount was reduced to 6,100, and this is for Unit 313.
Right.
Correct. And we're also asking the same, consideration, if you could lower that down too, because the tenant is not there. Even as of today, I have no tenant anymore there. Yeah.
Also, the tenant that left the premises is here with us today. There was a situation where the controller of their firm was leasing that property, that space. She gave a letter of resignation in September, and she left. And he sent us an order to cancel the lease, which we did.
And I think if you have a record, maybe she came in here for I don't know, was it a hearing or something? And she came and talked to you guys, and she asked. And so she was going through the process
Right.
of getting the license. She had code and she had inspections lined up.
Right.
But then it's unfortunate that she left. So,
And when she left, she didn't provide him the process of what was happening.
Is he the new tenant, or I'm a little
no,
confused?
You want to state your name for the record
My name is Abio Ballesteros.
in the microphone?
My name
please?
is Abio Ballesteros, and the company is SAR Property Management. And my controller, Wilhelmina, I gave her notice to leave the company
When was that?
September 13th,
Of?
2024.
Okay, but this violation, and this is on number 8403, this violation was issued April 11th of 23.
Yes.
Right. She was under the understanding that she came to a hearing. The controller.
8403, right? Case number 8403.
Case number 8403.
Right.
Yes, there was someone present at the formal hearing,
Right.
which was in July 18, 2024.
2024.
She was in the process
Yeah.
of curing the problem.
Okay, at that time, by the time it came to hearing, okay. And she shortly thereafter left.
Correct.
Okay. And the property remained vacant until,
It's still vacant.
It's still vacant.
okay. And like the prior case, there wasn't sufficient communication with the town. Okay, got it. Okay, I'll go ahead and give oral pronouncement. Anything else by either side? Okay, and the town has reduced this by 85%, the record reflects. Is that correct, Officer Ramirez?
Yes.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for abatement. The town has reduced the fines from 40,100 to 6,100. The respondent has requested a further abatement, which I will grant, and reduce the amount to $5,100 for case number 8403. The respondent is ordered to pay this mitigated amount within 30 days, or the original amount will resume. Good luck to you.
Thank you.
Thank you.
These are my least favorite. Okay. Thank goodness it's the same amount.
Three.
Okay, thank you. And then this is page 2. Okay, we can call the next case. Thank you.
Next case on section 7.4 on the agenda, case 10350. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 10350. Property owner MLR Marketing Corp., site address 3300 Southwest 55th Avenue, Pembroke Park, Florida. A notice of violation was sent by regular mail, November 8, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail, April 11, 2025. Posted to the property May 7, 2025. Posted to Town Hall May 9, 2025. The violations are for installation of windows without a permit, installation of shed without a permit, construction silt prohibited, remove construction silt from fence. And item number 4, new AC units mounted on roof without permits. As of April 10, 2025, re-inspection of this violation, affidavit of noncompliance was issued. So far, the owner has taken care of the removal of the shed. The construction silt was removed. And the AC units was inspected by our chief mechanical inspector, which he has removed the violation. And so it's only one item remaining, which is the permits for the windows. So it is my recommendation to give 90 days, if not a per diem of $250 and $100 admin fee.
Good morning. In the microphone.
She doesn't speak English. Is it for somebody? She speaks Spanish. Does somebody translate, or do I? I came with her for that, just in case she needed assistance.
Okay.
Chief Assistant.
Unless there's no objection on part of the town, she brought her own translator. You've been sworn.
I'm a family member. I'm not like officially a translator. That's why I want to know. It's you guys that translate, or I do.
I'll have to swear you in as a translator.
That's fine.
Okay, so in the microphone. Do you swear and affirm that your translation from English to Spanish and Spanish to English will be the truth and nothing but the truth?
I do.
Okay. So the town has presented its case, and it looks like for the items that have been cited, there's one item remaining that needs to be taken care of for this violation to be in compliance, and that is there was installation of windows without a permit.
She did get the permit for the windows yesterday.
Okay.
To my understanding.
Yes, so she needs to complete the permit to be in full compliance.
I'm sorry. What is the owner's first and last?
Oh, Virginia Loza.
Thank you, Madam Clerk. Ms. Loza, you translated that she obtained the permit on yesterday?
Yes, for
Okay.
the windows.
Okay, so the town is proposing, offering 90 days to come into compliance, or a $250 per day daily fine, and $100 for the administrative cost for today's hearing.
Sí, ya le dieron la extensión por eso.
Por
Por lo
permiso.
de las ventanas. Eso ya está, le dieron la extensión.
Me dieron el
Sí.
el pago, el certificado de que ya
Pero
está.
vos viniste acá ¿por qué? Por esto.
Por esto, por todo.
Sí, pero esto está pendiente.
Estos son los aire acondicionados que son viejos
Ajá.
y que
necesitaba una extensión para cambiarlo.
Let her know that the only violation she has to cure right now is the permit of the windows. She has to complete it to be in full compliance. All the other violations have been removed.
Claro, todas las otras violaciones ya te las han sacado.
Sí.
Lo único que está pendiente ahora es que tenés que completar lo de las ventanas durante el periodo que ellos te dieron. Después el resto ya está listo.
Okay. Perfect.
So she understands she has 90 days. If not, a $250 per diem will start to accrue.
90 días para que terminen esto, lo de las ventanas.
Ujú.
Si no, después te cobran una multa de 250 por día.
Okay.
And she will owe a $100 administrative fee for today's
Yeah, we
hearing.
have that.
Okay.
Perfect.
Okay.
Okay, if there's nothing else by either side, I'll go ahead and give oral pronouncement. You can translate.
¿Tienes algo más para agregarle antes de que ya diga lo final?
No, únicamente
No,
el
es que esto, olvídate de esto porque no existe.
ok.
Es las ventanas hoy en día.
perfecto. No. No, thank you so much.
Los 100 los tenés.
Sí. Sí, acá los.
We're good.
Okay, thank you. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance and is ordered to do so within 90 days or face a $250 daily fine, which will continue to accrue until the property is in compliance. The respondent is also assessed a $100 administrative fee for today's hearing. Good luck to you.
Thank you.
Thank you so much.
Virginia, is that how you spell your last?
No, sí, as in Seaward. Okay, fix it.
Thank you.
And now we wait here.
Yes, she'll give you the floor.
Thank you. Whenever you're ready, Officer Ramirez.
Okay. 10719.
Okay, next case is on section 7.9 of the agenda, case 10719. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 10719. Property owner Garden Property 786 Inc., site address 2950 Southwest 32nd Avenue, Pembroke Park, Florida. A notice violation was sent by regular mail February 26, 2025. A notice of formal hearing with a copy of the notice violation was sent by certified mail April 17, 2025. Posted to the property May 7, 2025. Posted to Town Hall May 9, 2025. The violations are for more than one light sign on window area. Only a 2 square feet non-flashing, non-animated sign is allowed. Item number 2, animated sign on the property. Animated signs are prohibited. Item number 3, mobile vendor on premise operating without a business tax receipt from the town. As of April 14, 2025, item number 1 and number 2 have been corrected. The only pending violation for correction is the business tax receipt and certificate of use of the mobile vendor. So it's my recommendation to give 60 days, if not a per diem of $250 and a $100 MN fee.
Is anyone here on this case? Good morning, come on up.
Good morning.
Good morning.
Morning.
So, the testimony of the officer indicates that you have a couple of things to complete to be in compliance, and offering you 60 days or a $250 daily fine, and of course the $100 administrative cost. So before you begin with your testimony, please state your name for the record and who you are in regards to the subject property.
Mishuk Hussein, I'm the leaseholder.
Okay.
Maria Vilera, I'm the owner of the mobile
Okay.
truck.
So,
I'm sorry. Maria, how do you spell your last name?
Billeda.
D as in David?
Yes.
Okay, thank you.
so which one will be presenting?
No, I'm asking here to the city for the BTR license. I have all the papers. The only missing paper I have is the survey.
Okay.
Then I come in since April 15, and I come in almost every week to ask him, but they say it's a little busy, number one, and number two, they try to fund them, but they can't fund them yet. I'm talking with Mr. Jeffrey, I hope.
Okay.
He sent me an email, and he tried to fund on the survey of this address because I think we need the survey to put the location of the truck, and then the inspector can go and finally, do everything to see if we can get the license. But I submit all the papers. The only issue I have is the survey.
Okay. The town is giving you 60 days
Yes.
to correct this one piece of violation.
Okay.
And it looks like this is a repeat violation.
No.
No. Okay.
Just for clarification, we have one pending violation, correct?
Yes, which is the business tax receipt and certificate of use of the mobile vendor.
This is case number 10719, correct?
Yes.
Is 60 days sufficient for you?
Can we get 90?
Yes. Is there a reason why you need more extension?
The city is unable to verify the survey if they have it or not, so maybe we'll need to do the survey ourselves. So we're not sure how long that takes. So 90-day time will give us.
All right, understood.
It's showing repeat. 107.
90 days is fine too.
Okay. We're just you're confirming. Can you give us 1 second? It is or it isn't? Okay, thank you. If there's nothing else by either side, I'll give oral pronouncement. No objection from the city for 90 days. Based on the evidence and testimony presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 90 days or face a $250 daily fine, which will continue to accrue until the property is in compliance. The respondent is also assessed $100 administrative cost for today. Good luck to you.
Thank you.
We'll call the next case. Next case.
Okay. Next case on section 8.8 on the agenda, case 9195. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9195, property owner Mita LeCroix, Benson and Barronville, Marie Augustine, site address 4800 Southwest 36th Court, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail April 11, 2025, posted to the property May 7, 2025, and posted to the town hall May 9, 2025. The property owner is working diligently in completing the permits for the addition. Therefore, my recommendation is to give 90 days, if not $100 per diem and $100 admin fee.
Is there anyone here on this case? Good morning. If you could kindly state your name for the record and who you are in relation to the subject property.
Sure, Mitsa Lacroix, I'm one of the owners.
Okay, and you can bring the mic just a little, yeah, perfect. So the town's offering 90 days or $100 per day if you don't come into compliance within that time frame.
I agree.
Okay. Be sure that you continue to work with the city and getting the violation closed out. Nothing else by either side. I'll give oral pronouncement. Based on the evidence and testimony presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 90 days or face a daily fine of $100 per day, which will continue to accrue until the property is in compliance. The respondent is also assessed $100 administrative fee for today's hearing. Next case.
Thank you.
You're welcome. Good luck to you. Thank you. 90, 100, 100. Members.
Okay. $94.84. Okay. Next case is on section 10.6 of the agenda, case 9484. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9484. Property owner Meat Bar Holdings LLC, site address 2540 Southwest 30th Avenue, Pembroke Park, Florida. A notice of hearing to abate fine was requested May 19, 2025. It is the town's motion to reduce the fine of $49,550 to $7,603. And there's another case as well. I'll read that one into the record as well.
I think that's the person signed in again on number 11, so I think that's just an extra.
No, there's two cases for this
Two
one.
cases here?
Yeah.
Okay.
The next section, is section 10.7 the agenda, case 9485. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9485. Property owner Meat Bar Holdings LLC, site address 2538 Southwest 30th Avenue, Pembroke Park, Florida. A notice of hearing to abate fine was requested on May 19. It is the town's motion to reduce the fine of $19,350 to $2,988.
Good morning.
Good morning.
If you could please state your name for the record.
Camille Barshishat.
Okay, we'll take up the first case, which is case number 9484. It looks like the town has reduced your fine from plus $49,000 to $7,603.
My apologies for interrupting. Is it Camille or Camilla?
Camille.
So Camila?
ILLE.
ILLE. Okay.
So what's your name for the record and who are you in relation to the property?
Camille Barshishat, and I'm the owner's assistant.
Okay, and you're here with the owner's permission?
Yes.
To speak on his or her behalf?
Yes.
Okay, so it looks like for case number 9484, we're looking at coming from a fine of $49,350 down to $7,603.
Okay. I wanted to know if we can reduce it more, as when we bought the building, it had, I guess, a lot of problems. And when the tenants came in, they were trying to get BTRs for a while. We went through life safety plans and changes and everything. Jean was our code enforcer, and then the tenants had to end up leaving. They left, one of them in the middle of the night, and the other one just left. So I'm stuck with all the fines. Now we're in compliance of everything, and just basically, we're stuck with all the fines.
The record does reflect that although the violation was cited back in a little over a year ago, because we're now in May. See, the final order was issued actually approximately a little over a year ago. Why did it take you so long to come into compliance?
So when they left,
When did they leave?
a while ago, and Gene came and he took pictures and he saw that everything was vacant, and I guess they didn't update the systems here. And then we filled the forms, and until I sat with Jeffrey and filled the forms out again, and he came again and took pictures, and we made sure that it did update in the systems, then it just kept occurring. So the fines just kept getting higher and higher. I didn't even know that, because I met with Gene on the premises after the tenants had left over a year ago, and I guess he just put it in the system here.
Does the town have any record of this?
I don't have any records of that, but I did, if the tenant or Ms. Camille, if she submitted an account cancellation form for the BTR, because that's one of the processes of the town. If you started a business tax receipt application and you're no longer going to move forward with it, you submit an account cancellation request form. And that was submitted. I requested it from our business tax receipt department, so I put the compliance date as the date of that application that we received.
Oh, which would have been
April 7th.
Of this year.
Yeah. And I only learned about this matter on Monday.
Okay.
And we filled it out before with Gene as well. I filled it out the second time with Jeffrey and Gene. And I guess it was lost, or I don't know, so.
Okay. Anything else?
No.
No.
Give me 1 second. Okay, the town has reduced for case number 9484 to $7,603. I will, based on your representation, there's no testimony or evidence that contradicts that. I'll reduce that further down to $6,103. Let me give oral pronouncement. Based on the testimony and evidence presented, there is substantial and common evidence to approve a request for abatement of the fine on case number 9484, in that the property is in compliance. The town has reduced the fine amount from $49,550 down to $7,603. Respondent has requested an additional reduction based on the testimony offered. No testimony contradicts. I will grant the further request down to $6,103. That amount must be paid within 30 days, or the original fine amount of $49,550 will resume. Your next case is case number 9485. And so on that case, the town has reduced it down to $2,988.
Okay.
Okay. Based on the testimony and evidence presented, there is substantial competent evidence to approve the request for case number 9485. The reduced amount is $2,988. That amount must be paid within 30 days or the original amount. And give me 1 second so I can state on the record the original amount, or the original amount of $19,250 will resume. Okay?
Okay, and we can't reduce that one either because it's the same story.
I'll correct that. I want to correct the amount. For case number 9485, the original fine amount is $19,350. The town has reduced that down to $2,988. That amount will remain confirmed.
Okay.
Okay? Is this the first case or the second case?
First case.
Okay.
That's 6, 1, and 3.
Okay, thank you. That's by code unless they ask for more time. Okay. And then this one is 2988. We can call the next case. Thank you.
Next case on section 7.6 of the agenda, case 10431. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 10431, property owner Drew Boy Inc., site address 5590 West Honda Beach Boulevard, Pembroke Park, Florida. A notice violation was sent by regular mail December 16, 2024. A notice of formal hearing with a copy of the notice violation was sent by certified mail April 17, 2025, posted to the property May 7, 2025, posted to Town Hall May 9, 2025. The violations are for interior renovations done without building permits, outdoor storage prohibited, remove chairs, materials, equipment, and miscellaneous items, and store inside building. As of April 14, 2025, the outdoor storage has reduced substantially. However, there's still some miscellaneous items that need to be removed. And as for item number 1, interior renovations done without building permits, I was told today that there is an application with a process number. So it's in progress. Therefore, it's my recommendation to give 90 days, a per diem of $250 and $100 admin fee.
Is there anyone here on this case? This is case number 10431.
Yes.
Good morning. State your name for the record and who you are in relation to the subject property.
Paul Neal. I'm the business owner.
Okay. You're the business owner. You're operating at that site?
Yes.
Okay. Are you here with the owner's permission?
Yes, I am.
Okay. So the testimony of the code officer, and this is a repeat violation, Officer Ramirez?
One moment. No.
No? Okay. And this was 90 and 250?
Yes.
Okay, so the town is offering 90 days for you to come into compliance. If not, there will be a daily $250 fine that will continue to accrue until the property's in compliance.
What is left?
You have to remove like the miscellaneous items in the back end of the property, and yeah, the remainder, and complete your permit. You have to come to full completion of the permit.
You guys got
Right. As I stated earlier, I was told today that you got an application in process. You just have to complete it. Mhm.
all right. That's fine.
Nothing else on either side. I'll give oral pronouncement based on the testimony evidence presented. There is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 90 days or face a daily fine of $250 per day, which will continue to accrue until the property is in compliance. There's also a $100 administrative fee assessed for today's hearing.
Okay.
Okay, good luck to you.
All right, thank you.
Is there an order on this? Oh, okay. You know, I'm always concerned. The owner's not here because 90 days will come in. Right. We can call the next case.
Next case is on section 8.12 of the agenda, case, 1 second.
All four for extensions.
Actually, it's, the first one is on section 8.9 of the agenda, 9269. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9269. Property owner, Pembroke Road Center LLC, site address 3940 Pembroke Road, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail April 11, 2025, posted to the property May 8, 2025, posted to Town Hall May 9, 2025. As of, it's been a while. There's currently 6 violations. And give me a moment. And I know they're currently working on their business tax receipt and the tenant build-out permits. Sometimes when there's tenant build-out permits, there's a hold on the BTR. So they won't be able to move forward until they submit and complete all permits. There's also ceiling leaks that need to be repaired. So it's my recommendation to extend the time to 90 days. If not, a per diem of $250 and $100 admin fee.
Good morning. If you could state your name for the record and who you are in relation to the subject property.
My name is Jared Harper, and I'm the property manager.
And you're here with the owner's permission and authority to speak?
Yes.
Okay. So it looks like there was previously a final order, and now there's a request for an extension, which would provide 90 days to come into compliance, or the $250 per day daily fine will begin to accrue.
Okay, yes.
Okay.
I understand.
Nothing from either side based on
I do have one thing.
Okay.
I know that this tenant, they're not here today. I know that they were working on everything, and as for like the ceiling leak, I know that we got this entire roof replaced back in February. So I don't know what we need to
That
submit.
permit completed?
Huh?
Is that permit completed?
The permit was completed and everything was signed off by the city, and
Was the ceiling also repaired?
that part I'm not sure of for the inside of the tenant space. I asked them if it was, and I assume that they would be here today. But it's, with the 90 days, I'll confirm that everything's taken care of.
Okay.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for extension of time. Respondent is hereby ordered to come into compliance within 90 days. Failure to correct the violation and come into compliance will result in the fines of $250 per day accruing until the property is in compliance, and there's a $100 administrative fee assessed for today's hearing. Good luck.
Next case on section 8.12 of the agenda, case 9700. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 9700, property owner Pembroke Road Center LLC, site address 3936 Pembroke Road, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail, April 11, 2025. Posted to the property May 8, 2025. Posted in Town Hall May 9, 2025. The violations are for a business tax receipt and a tenant build out. Currently, therefore is my recommendation to give an extension of 90 days, a $250 per diem and a $100 admin fee.
Okay, if you could state your name for the record once more and who you are in relation to the subject property.
Good morning, Bonnie Gilbert, and I'm the tenant.
Good morning.
And I'm Jared Harper, the property manager.
Okay, so it looks like for this case as well, Mr. Jarrett, the town is offering a 90-day extension with a $250 per day fine and administrative cost of $100. I see the tenant is here on this case. Is there anything that you want to add? It looks like the BTR.
I know that the permits and
filled out.
everything were filed for, and I know once that's completed, she'll be able to get the business tax.
Okay, and I'm not sure if I heard, was a permit application submitted?
Yes, ma'am.
Okay. Okay, perfect. So nothing else by either side. I'll give oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for an extension. The respondent is ordered to come into compliance within 90 days. Failure to come into compliance and correct the violation will result in the fine of $250 per day accruing daily until the property is in compliance. Administrative fee of $100 are also assessed. For the record, this is case number 9700. We'll be able to give you a copy of the order if you could just give us 1 second. $92.
Okay, thank you.
Did I sign it?
Yes.
You sure?
Yes.
Oh, okay. I did not remember that. $90. You sure I stopped midway? Okay, I trust you.
I mean, I'll go check. I gotta make the copy and it's over there.
Okay, perfect. Yeah, take a look. We can call the next case.
All right. Next case on section 8.13 of the agenda, case 9963. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 9963. Property owner Pembroke Road Center LLC, site address 3932 Pembroke Road, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail April 11, 2025. Posted to the property May 8, 2025. Posted to Town Hall May 9, 2025. The violations are for demolition work done without building permits, installation of cameras without permit, and any new business must obtain their business tax receipt and certificate of use prior to operating. Again, currently, I know that the tenant is working on the completion of the permit, and they're not operating in the unit. So that corrects violation number 3. So it's my recommendation to give 90 days to complete the violations, and a $200 fee per diem and a $100 admin fee.
Again, my name is Jared Harper. I'm the property manager. I did speak with the tenant's contractor earlier this week. He stated that the permits were approved, so I believe that now they can go in and do the work, and I'm not sure how that process works with, does he have to complete all the demolition and everything and the build out before the permit can be closed? And also he did mention that there were never cameras, so I'm not sure about that, but I do appreciate the, since they're not operating, the business tax already being mitigated.
As to your first question, yes, the permits have to be closed, and that means an inspection from the building division or department confirming that the work was performed in accordance with the permit and the plans submitted before that violation detail can be cleared out. Officer Ramirez, do you have any information you can further add by way of the cameras based on Mr. Jared's?
There's cameras on the pictures. It's a tiny camera, so it's hard to see, but it's on the ceiling.
It's on the ceiling inside the space?
Mm-hmm.
Okay. I've only been inside the space once, so I would have to look.
It's go to the last page. No, all the way down. Yeah. All right, there's one there.
Okay.
And then the other one is on page 39. I think there's another one there too. Yeah. And there you go. That's the other one.
Okay.
Okay, so you can communicate with the.
Yes, I'll speak with the tenant and the contractor.
Okay. If nothing else by either side, I'll give oral pronouncement. Based on the testimony evidence presented, there is substantial and competent evidence to approve the request for extension of time. The respondent is ordered to come into compliance within 90 days or face a $250 per day daily fine, which will continue to accrue until the property is in compliance. The respondent is also assessed $100 administrative costs, and this is for case number 9963. Next case.
There's another case that was listed when you signed in. That was case 9989. That the beginning of the hearing, it was mentioned it was removed because it was complied
Okay,
for the
great.
hearing date. Yeah.
All right, thank you, sir.
But you still owe the administrative fees on that case, okay?
Okay. And that'll come via mail to the owner?
No, you have it listed on your final orders. Every time you receive a final order, it's
on
listed on there. Yeah.
Okay. All right.
Okay, so case
I
9989.
have one more question. For those pictures of the camera, since I've never seen that, would you be able to forward that over to me?
You can request a public record request and send me an email or the town clerk, and we'll send it to you.
All right, thank you.
Okay, good luck to you. So that's closed, complied. We have a couple of people left. Okay. Okay, perfect. Thank you, thank you.
An extension, right?
It's freezing in here now. Or is it my imagination? It's getting kind of cold. Whenever you're ready. Yeah.
Next case on section 8.7, case 9157. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 9157. Property owner Ana Maria Gonzalez or Unieski Padilla Gonzalez. Site address 135 Stephen Street, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail April 11, 2025. Posted to the property May 8, 2025. Posted to Town Hall May 9, 2025. Violations are for mobile home ceilings are caved in. Item number 2, mobile home has substantial water damage. Mold-like substance, nuisances, and unsanitary nuisances are present. Item number 3, mobile home is inhabitable and unsafe. The current owner has been working diligently to cure these violations. They recently completed a roof permit to fix the damages on the roof. However, they still have to work on getting permits for the ceilings repairs. And they did provide a mold remediation report. So again, they are working on it. They need time to complete those permits and make those repairs. So it's my recommendation to give 90 days, $100 per diem, and $100 admin fee.
Okay. Good morning. Can you state your name for the record and who you are in relation to the subject property?
Yes. I need one extension for more time.
Okay. Can you speak in the microphone?
Yes. Hi. I need more extension.
You need more time. But tell me your name and who you are. Is this your property? And tell me your name.
Unieski Padilla Gonzalez.
Mr. Gonzalez?
Yes.
And you're the owner?
Yes.
Okay. You're not living in this property, are you?
No, no.
Okay. Because the photos doesn't look habitable. So the town is offering you 90 days, and you're saying you need more time. I have a question. You've applied for a permit?
Yes.
Okay. The permit when did you apply for a permit?
Now the contract is working for documentation for the other permits.
Okay. How much, so 90 days is not going to be enough. How much time do you think all of this will be in compliance?
For now, 90 days is fine.
90 days is fine?
Yeah, for now, yeah.
Okay. And this was 90 days, and the per diem was?
100.
100, okay. So, Mr. Gonzalez, you have 90 days to close out the permit, do all the work, pass inspections, and close out the permit, and then contact Officer Ramirez to let her know. If you do not come into compliance in 90 days, it will be a $100 fine that will add up 100 compliance.
Okay.
Okay? Nothing else by either side. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 90 days or face a $100 per day per diem fine, which will continue to accrue until such time as the property is in compliance. The respondent is also assessed $100 administrative fee for today's hearing. Next case.
Next case on section 7.1 of the agenda.
Thank you.
Case 10110. Chief Code Compliance Officer Joseline Ramirez for the town of Pembroke Park. Case 10110. Property owner Infinity Azure LLC. Site address 5491 Southwest 34th Street, Pembroke Park, Florida. A notice of violation was sent by regular mail September 3rd, 2024. A notice of formal hearing with a copy of the notice violation was sent by certified mail April 17, 2025. Posted to the property May 7, 2025. Posted to Town Hall May 9, 2025. The violations are for in bedroom and bathroom area, the ceiling is caving in. Unit is currently under construction and dust particles are falling in the interior of kitchen and living room area. Property owner has to repair ceiling as soon as possible to avoid the ceiling from falling and for dust particles to fall. This is a health and safety violation. As of April 14, 2025, the property owner did complete the roof permit for that particular unit, and there was no longer dust particles. However, the ceiling in the bedroom and bathroom area are still caving in. This has to be repaired. Per the building official said that the ceiling has to be flat. So it's my recommendation to give 60 days to make these repairs, if not a per diem of $250 and $100 admin fee.
Good morning. Is there anyone here on this case? This is case number 10110, property address located 4591 Southwest 34th Street. Seeing or hearing no one come forward, based on the testimony and evidence presented, there is...
Excuse me, sorry. Somebody signed in, Mark Katz.
Is anyone?
Is there anybody in the audience, Mark Katz?
Nope. Okie dokie.
Okay, then no one is present, sorry.
Okay. Seeing or hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 60 days or face a $250 per day daily fine, which will continue to accrue until such time as the property is in compliance. The respondent is also assessed $100 administrative fee for today's hearing. Next case.
I'm sorry. I don't have the people in the audience on the list.
Right. That's what I wanted to know. I have 7277 Tania Nichols is next.
7277.
Mark Katz is not available.
Tania Nichols. And who's... Can you sign in? Oh, no, say it's going to.
They speak English?
I have no idea.
Is it her?
No, I'm sure Tania Nichols was for 7277. I'm just not sure who those two gentlemen in the background.
They didn't come for any case.
Okay,
They're
just
here
have them
to
sign in.
spectate? Okay. Okay.
Okay, so they're not here for any particular case.
So then it's just 7277. That's next.
Okay, so we'll move.
I see 3 people in the back.
Yeah, they're not here for anything.
Okay.
We'll move forward with 7277.
The respondent.
Right. That's what I thought we would. That's fine.
Okay. Well, I did call the address.
Yeah.
And ask if anyone is here.
I'm not sure why they would.
They should at least tell. Well, the record should reflect they left. Because we would have.
For an update, right?
Let's put it on the sign.
72.
Yeah, that they left. We did call the case.
We're not in attendance.
Right. So this is 7.
277. Pero no se van a presentar, ¿verdad?
Oh.
I mean, she was giving her business card though. Okay, okay. Not a problem.
What's the case number for?
She's on what case?
727.
Okay, so we have to make a correction on the agenda, because right now, case 7277 is for confirmation of fine, which we made the modifications. We presented them earlier, but it has to be added for an abatement of fine. So it, right now, currently is on section 9.3 for confirmation of fine. And let the record reflect that we have to make this administrative correction. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7277, property owner Cobblestone 2 B&B LLC, site address 2430 Charles Road, Pembroke Park, Florida. A notice of hearing to abate fine was requested. It was requested yesterday, May 20, via email. And it is the town's motion to reduce the fine of $121,100 to $18,250.
$18,250. And the original fine amount is 120.
$121,100.
Got it. Good morning. If you could state your name for the record and who you are in relation to the subject property.
Tanae Nichols. I am the property manager for Bamboo MAC Cobblestone.
Okay.
May I jump in, Ms. McKinney?
Yes.
Sure. So just for the record as well, Ms. Nichols is an employee of the city of West Park. And I am the magistrate for the town of West Park. So I want to add that to the record. Given the fact that Ms. Nichols, you're here, this is in your personal capacity and has nothing to do with anything with the town of West Park, correct?
Correct.
Okay. And I want to make sure if anyone, if there's an issue as far as any type of relationship between Ms. Nichols and myself, then I'm happy to recuse myself as needed. But given the fact that this is not dealing with the town or her personally, this is regarding Cobblestone. I defer to the town, but I also want to just to make the record and just to be clear so there's no impropriety or at least a view of impropriety. I wanted to put that on the record before proceeding.
Okay. Thank you. Okay. Welcome, Ms. Nichols. And so you are here with the owner's authority to speak on this abatement.
Yes.
Okay. So it looks like this was a fine that is or was at $121,100, and the town has recommended a reduction of $18,250, which represents an 85% reduction.
Correct. And I would like to have it reduced even more to 3 digits if I can.
3 digits. I have to take a look.
And I'm requesting this because everything. The town itself has received approximately $196,000 in permit fees just for the seawall, and the project itself cost the company over $1 million. I have the receipts. Another one of the issues or violations was the landscape. There's a contracted company that comes once a month to cut the grass and prune the trees. Also a part-time maintenance person. There's also a property manager part-time, myself. The paving has been done as well through permits, and everything is closed. So seeing that the city already got approximately $250,000 in permit fees and everything is in compliance, I think it could be reduced if possible, please.
Okay. My first question is, what's the city's position to a reduction of three figures?
Do you have a number in mind?
I was hoping for maybe $500 to cover administrative fees.
Well, I can tell you that even if the city were to agree, I would not be in agreement with, I would not be accepting $500.
Okay.
So,
Given the circumstances, because they did build a seawall, it's a very lengthy project. And as they mentioned, they did spend a whole lot of money on it. With the benefit, that the residents are gonna be better off. The city's position, we can go to 90% reduction, and we'll calculate that right now. One second. That'll be 12,200. And we normally don't do this. We normally don't go beyond the 85%, but because it's for the betterment of the community, I think that the city will allow it this time. So it's 12,200 if we reduce it for 90%.
I accept.
okay. We have an agreement between the parties. If nothing else by either side, based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for abatement. The property is in compliance. The fine are mitigated or abated down to from $121,100 to $12,200. This represents a 90% reduction based on the betterment to the community, the compliance of the property, and the building of a seawall for the additional reduction. This includes the $100 administrative fee in that amount.
Yes.
Now, this amount of $12,200 must be paid within 30 days, or the original amount will resume. Good luck to you.
Thank you.
Thank you.
That appears that concludes your in-person docket.
I know my handwriting. Thank you. Oh, the room is empty. Does anybody need a break or? Okay.
Yeah.
5-minute break.
We'll wait for Mara to put.
We are live. Just give it a minute. Make sure the video is working.
I just got back from Virginia for a conference.
Okay, we're live.
How was it?
It was awesome. I got to see a little bit more of DC.
Yeah.
Yeah.
Okay, since there is no one in the audience, we will continue in the order of the agenda. Next case on section 7.2, case 10161. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 10161. Property owner Infinity Azure LLC, site address 5253 Southwest 33rd Street. A notice of violation was sent via email 9/13/2024. It was sent regular mail September 16, 2024. A notice of formal hearing with a copy of the notice violation was sent by certified mail April 11, 2025, posted to the property on May 7, 2025, posted to Town Hall May 9, 2025. Violations are for damaged AC unit not operating. A licensed contractor will need to make repairs. Item number 2, installation of water heater without a permit. As of April 10, 2025, upon reinspection, the water heater has not been corrected and the AC unit was changed out without a permit. Therefore, it's my recommendation to give 60 days to comply, and this is a repeat offense. 60 days to comply, if not, a per diem of $250 and $100 admin fee.
Would you kindly put the repeat case number on the record?
Yes. Give me a second. I think it's on this agenda as well. Give me a moment. One.
Man, it's really cold.
That's case 7393.
Thank you. Case number 10161, property located 5253 Southwest 33rd Street. Is anyone here on this case? Seeing and hearing no one, go forward. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. This was cited as a repeat offense?
Yes.
Okay. This is a repeat violation case number 7393. The respondent is ordered to come into compliance within 60 days or face a daily fine of $250 per day, $250 per day, which will continue to accrue until such time as the property is in compliance, and $100 administrative costs. Next case.
Next case on section 7.3, case 10204. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 10204. Property owner Plaza Hal Corp. Site address 4400 West Halldale Beach Boulevard, Pembroke Park, Florida. Unit number 1. Notice violation was sent by regular mail October 4, 2024. A notice of formal hearing with a copy of the notice violation was sent by certified mail April 11, 2025, posted to the property May 7, 2025, Post Town Hall, May 9, 2025. The violations are for item number 1, prohibited banner on premise. Item number 2, signs are covering more than 25% of the window. Item number 3, installation of electrical cameras without permits. Item number 4, advertisement for business without business tax receipt or certificate of use. As of April 10, 2025, item number 1, the banner and the covering of the windows, 25% has been corrected. The permits for the cameras still have not been obtained. Give me 1 second. And the business tax receipt still has not been obtained. So it's my recommendation to give them 60 days to correct those 2 violations. If not, a per diem of $250 and $100 admin fee.
Case number 10204, property located at 4400 West Hollandale Beach Boulevard. Is anyone here on this case? Seeing and hearing no one come forward, based on the testimony and evidence presented, there is substantial competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 60 days or face a daily per diem fine of $250 a day, which shall continue to accrue until such time as the property is in compliance. The respondent is also assessed a $100 administrative fee for today's hearing. Next case.
Next case is on section 7.7 of the agenda. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 10518, site address 3946 Southwest 48th Avenue, Pembroke Park, Florida. Property owner Ana Claudia Vasconcelos Mauricio and Luis Vandel Bo George. A notice of violation was sent by regular mail, January 9, 2025. A notice of formal hearing with a copy of the notice of violation was sent by certified mail, April 17, 2025. Posted to the property, May 7, 2025. Posted to Town Hall, May 9, 2025.
Someone's trying to.
Someone's trying to come in?
Yeah.
Can you open the door, Naz? Before they drive away? For item number 1, installation of canopy without a building permit. Item number 2, installation of AC mini split without a building permit. Item number 3, installation of cameras without a building permit. As my inspection, I'm sorry, I believe I did an inspection last week. I don't have the date with me. The canopy has been removed, but they need a permit. They need to complete their permit, and they have started a process for the permit. They just need to complete it. They need a permit for the removal of the AC mini split. And the cameras, they showed me that they had 2 dummy cameras in the front door and that the cameras in the back end of the property were removed. And they also proved that those cameras were plug-ins. So there was like some wiring plug-ins that you put it inside your home, like you drill it and you put it inside your home. So we just needed to verify if they were electrical or if they were just plugins. So they need still permit completions for item number 1 and 2. Therefore, it's my recommendation to give 90 days, $100 per diem, and $100 admin fee.
Case number 10518, property located at 3946 Southwest 48th Avenue. Is anyone here on this case? Seeing and hearing no one come forward. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that violations still remain on the property. The respondent is ordered to come into compliance within 90 days or face a $100 per day daily fine, which will continue to accrue until the property is in compliance. The respondents are also assessed $100 administrative fee for today's hearing. Next case.
Next case on section 7.10 of the agenda, case 10769. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 10769. Property owner 3680 W LLC. Site address 3680 West Houndel Beach Boulevard, Pembroke Park, Florida. A notice of violation was sent by regular mail March 21, 2025. A notice of formal hearing with a copy of the notice of violation was sent by certified mail April 28, 2025, posted to the property May 7, 2025, and to Town Hall May 9, 2025. This is a repeat violation. The other case is on the agenda as well. Confirmation of fine. Which is 9937.
9937, repeat case.
Just to confirm, we're on 10769.
Yeah. The violation was for piles of branches, trash, and debris on the property. Upon the failure of the property owner or owners to remove the conditions creating the nuisance as aforesaid within the designated time period, the town shall such condition to be removed and shall assess the owners of the property for such services in the amount equal to the cost incurred by the town in the removal and disposal of the garbage, trash, rubbish, and other debris, which cost shall include but not limited to disposal fee, removal expenses, including both labor and vehicular expenses, and administrative fee in the amount of $250. The estimated cleanup cost is $5,000, but it can be more than that. The property owner did fail to correct the violation in the time frame given, and since this is a repeat offense, we would like to begin the accruing fine from the date of correction, which was on March 21, so 15 days from that date. Let me see. I can get you the date. Just be 31, so it would be April 5th. What does the order say? Does it say April 5th?
No, it just says 15 days from that date.
From March 21?
Yeah, of 2025.
Okay. So then the accrual fee would start from, I believe it would be April 6th, 15 days. And they will have to also be responsible for all the cleanup costs. And so far, I have from the town, it was $4,658.20 for the labor, the rental of vehicles, and the picking of the trash and disposal. We also are pending an invoice from Waste Management, how much it costs them to dispose, actually the rental of the vehicles, the labor, and the disposal. So we would like to recover all the cleanup costs, and that verbiage is on the order.
Just to confirm, it's April 5th.
Okay. I said around there, yeah. April 5th or 6th. Thank you.
So just so I can clarify, prior to the pronouncement, the city is seeking a final order that orders the payment of fines commencing on April 5th.
No. Oh, yes, yes, go ahead. You're right.
Okay. This is a daily fine as well of $250. And is the administrative cost greater than 100? I'm just looking at the.
Yes, the violation says that when there's failure to correct, it's an administrative fee of $250.
Okay, so per diem fine will commence effective April 5th, 2025. Administrative fee of $250. And the respondent is ordered to pay all cleanup costs incurred by the city.
Yes.
Okay, thank you. Case number 10769, property located at 3680 West Hollandale Beach Boulevard. Is anyone here on this case? Seeing and hearing no one come forward, based on the testimony, competent evidence to support the town's position that this is a repeat violation case number 9937. The respondent is ordered to come into compliance or face a $250 daily fine beginning April 5th, 2025, which shall continue to accrue from that date until such time as compliance is achieved. The respondent is also assessed an administrative fee in the amount of $250. Respondent is also ordered to pay the town the cost incurred by the town for cleanup, and that is recovery of all cleanup costs incurred by the town.
Ms. McKinney, if I may?
Yes.
You can amend your pronouncement. You stated that they had to come into compliance or pay a fine. In this situation, it's
and pay a fine.
Thank you.
Thank you. Yes. Thank you for the clarification, Town Attorney. Just so the oral pronouncement is clear and supported by the written order, and that is the respondent must come into compliance and must pay all recovery cleanup costs and any and all fines that have accrued commencing from April 5th, 2025 and thereafter. Next case.
Okay. 5487.
Right. Yeah. Just want to make sure we're
The
considering.
next set of cases are all for extension of time.
Mm-hmm.
Are they for the same amount?
What?
The extension of time? Or they vary?
Vary.
Oh,
Yeah.
okay.
Mm-hmm. Are we gonna do a bulk?
That's what I was thinking.
We can go through quickly, but no, I think we need to hear each one.
Yeah. All right.
Make a finding, notice, even though it's generally agreed to, and
Next case on section 8.1 of the agenda, case 5487. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 5487. Property owner Mariel Tanzanier, Steve Lapointe. Site address 148 Westlake Drive, Pembroke Park, Florida. A notice of hearing to extend time was requested May 7, 2025. This is for interior renovation done without a building permit. Per the contractor, requested 60 days, so the town has no objection. Recommendation is 60 days with a $100 per diem and a $100 admin fee.
Case number 5487, excuse me. Property located 148 Westlake Drive. Anyone here on this case, seeing or hearing no one come forward? Based on the testimony and evidence presented, there is substantial and competent evidence to approve the extension of time. The respondent is ordered to come into compliance within 60 days or face a $100 day per diem fine, which shall continue to accrue until such time as the property is in compliance. The respondent is also assessed $100 administrative fee for today's hearing. Next case.
Next case on section 8.2 of the agenda, case 7382. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 7382, property owner Stephen E. McGill, site address 3911 Southwest 52nd Avenue, Pembroke Park, Florida. A notice of hearing to extend time was requested May 7, 2025. This is for replacement of meter without a permit. This was a repeat violation when presented back in August 10, 2022. We were told by the current owner that the previous owner passed away. So they're gonna do everything. So it's my recommendation that we give them 60 days, if not $100 per diem and $100 admin fee as requested.
Case number 7382, property located at 3911 Southwest 52 Avenue. Anyone here on this case, seeing or hearing no one come forward? Based on the testimony evidence presented, there is substantial and competent evidence to approve the extension of time. Respondent is ordered to come into compliance within 60 days or face a daily fine of $100 per day, which shall continue to accrue until such time as the property is in compliance. The respondent is also assessed $100 administrative fee. Next case.
Next case on section 8.3 of the agenda, case 8279. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park. Case 8279, property owner Steve Lapointe, site address 148 West Lake Drive, Pembroke Park, Florida. Notice of hearing to extend time was requested May 20, 2025. The violations are for installation of 7 impact windows without a permit. Currently, the contractor is working on a permit. It had expired before, they reinstated it, so therefore it's my recommendation to give 60 days, $100 per diem, and $100 admin fee as requested.
Case number 8279, property located at, sorry, that's not the case number we're on.
8279, yes.
Is it?
Yes.
I'm looking at the other name. Okay. Thank you, guys. Case number 8279, property located at 148 West Lake Drive. Anyone here on this case? Seeing and hearing no one come forward, based on the testimony evidence presented, there is substantial and competent evidence to extend the time for compliance. The respondent is ordered to come into compliance within 60 days or face a $100 per day daily fine. Failure to come into compliance within that time frame will result in the daily fine accruing daily until such time it's in compliance. The respondent is also assessed $100 administrative costs for today's hearing. Next case.
Next case is on section 8.4 of the agenda, case 8365. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park. Case 8365, property owner Trinity Broadcasting of Florida, Inc., site address 2250 South Park Road, Pembroke Park, Florida.
Okay.
A notice of formal hearing to extend time was sent by certified mail April 11, 2025. Posted to the property May 8, 2025. Posted to Town Hall May 9, 2025. Currently, they are working on correcting the violation for the parking lot done without a permit, the pave and restriping. So therefore, to complete the permit, I'm recommending 60 days, if not a per diem of $250 and $100 admin fee.
Case number 8365, property located at 2250 South Park Road. Anyone here on this case, seeing and hearing no one come forward? Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. I'm sorry, strike that. I'll restate the oral pronouncement. This is an extension. Thank you. I'm on autopilot. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for an extension of time. The respondent is hereby ordered to come into compliance within 60 days or face a $250 per diem daily fine, which will continue to accrue until such time as the property comes into compliance. The respondent is also assessed $100 administrative fee for today's hearing. Next case.
Next case is on section 8.10, case 9436. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 9436. Property owner Jean-Francois Morin, site address 4910 Southwest 28th Court, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail April 11, 2025. Posted to the property May 8, 2025. Posted to Town Hall May 9, 2025. The violation is for modified concrete steps and converted steps and convert it to raised patio without building permits. I was told that Mr. Moran is in Canada and he is facing health issues. So they requested an extension. So town's recommendation to give 90 days, $100 per diem, and $100 admin fee.
Case number 9436, property located at 4910 Southwest 28th Court. Anyone here on this case, seeing and hearing no one come forward? Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for an extension of time. The respondent is ordered to come into compliance within 90 days or face a $100 per diem daily fine, which will continue to accrue until the property is in compliance. The respondent is also assessed $100 administrative fee for today's hearing. I believe that's our last case.
The next one?
For extensions, yes.
Oh, for extension, yeah. The next case.
Making sure we're all still awake.
Next case is on section 9.2 of the agenda, case 7159. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7159. Property owner Carmen Yolanda Camano and Esther Elbas. Site address 119 Lone Pine Drive, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail April 17, 2025, posted to the property May 8, 2025, posted to Town Hall May 9, 2025. It is the town's motion to confirm the fine of $64,100.
Case number 7159, property located at 119 Lone Pine Drive. Is anyone here on this case? Seeing and hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. The fines are hereby confirmed. The respondent is still under an order to come into compliance and correct the violations. Failure to correct the violations and come into compliance will result in the daily accrual of the fine in continuing until it is in compliance. Respondent is assessed $100 administrative fee for today's hearing. Next case.
Next case is on section 9.5 of the agenda, case 7393. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7393. Property owner Infinity AZURE LLC. Site address 5325 Southwest 32nd Street, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail April 17, 2025, posted to the property May 7, 2025, posted to Town Hall May 9, 2025. It is the town's motion to confirm the fine of $1,250.
Case number 7393, property located at 5325 Southwest 32nd Street. Is anyone here on this case? Seeing and hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to confirm the fines. To date, the property remains out of compliance. The fines are hereby confirmed. The respondent still remains under an order to comply and correct the violation. Failure to correct the violation and come into compliance will result in the daily accrual of the per diem fine. Respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case on section 9.9 of the agenda, case 9090. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9090. Property owner Plaza Hall Corp. Site address 4400 West Handle Beach Boulevard, Unit Number 4, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail April 21, 2025, posted to the property May 7, 2025, posted to Town Hall May 9, 2025. It's the town's motion to confirm the fine of $46,850.
Case number 9090, property located at 4400 West Hollandale Beach Boulevard. Is anyone here on this case? Seeing and hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. The property remains out of compliance to date. The fines are hereby confirmed. Respondent is still under an order to comply and correct the violation. Failure to correct the violation and come into compliance will result in the daily accrual of the per diem fine. Respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case on section 9.10 of the agenda, case 9937. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9937. Property owner 3680 West LLC, site address 3680 West Honda Beach Boulevard, Pembroke Park, Florida.
Yes.
A notice of hearing to confirm fine was sent by certified mail April 28, 2025. Posted to the property May 7, 2025. Posted to Town Hall May 9, 2025. There's the town's motion to confirm the fine of $46,850.
Case number 9937, 3680 West Hollandale Beach Boulevard. Anyone here on this case, seeing and hearing no one come forward? Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. To date, the property remains out of compliance. The fines are hereby confirmed. The respondent is still ordered to comply and correct the violation. Failure to correct the violation and come into compliance will result in the daily accrual of the continued daily accrual of the per diem fine. Respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case on section 9.11 of the agenda, case 9981. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9981. Property owner Plaza Hall Corp., site address 4400 West Honda Beach Boulevard, unit number 4, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail April 17, 2025. Posted to the property May 7, 2025. Posted to Town Hall May 9, 2025. It is the town's motion to confirm the fine of $39,350.
Case number 9981, property located at 4400 West Hollandale Beach Boulevard. Is anyone here on this case? Seeing and hearing no one come forward. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. To date, the property remains out of compliance. The fines are hereby confirmed. The respondent is ordered to comply and correct the violation. Failure to correct the violation and come into compliance will result in the continued accrual of the per diem fine. Respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case on section 10.1 of the agenda, case 4945. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 4945. Property owner Quintero and Brothers LLC, site address 4908 Southwest 36 Court, Pembroke Park, Florida. A notice of hearing to abate fine was requested May 1st, 2025. It is the town's motion to reduce the fine of $14,700 to $2,375, and the owner is in agreement to this amount.
Case number 4945, 4908 Southwest 36 Court. Anyone here on this case, seeing and hearing no one come forward, based on the testimony and evidence presented and the agreement of parties, there is substantial and competent evidence to approve the abatement of fine from $14,700 to $2,375. This does include the $100 administrative fee. The respondent is ordered to pay the abated amount within 30 days. Failure to pay the reduced amount will result in the original fine amount of $14,700. Next case.
Next case on section 10.2 of the agenda, case 6544. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6544. Property owner Quintero and Brothers LLC, site address 4908 Southwest 36 Court, Pembroke Park, Florida. A notice of hearing to abate fine was requested May 1st, 2025. It is the town's motion to reduce the fine of $11,250 to $1,788.
Case number 6544, property located at 4908 Southwest 36 Court. Is anyone here on this case? Seeing and hearing no one come forward. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for abatement of fine. The fine is hereby abated from $11,250 to $1,788. This amount includes the $100 administrative fee. The respondent is ordered to pay this amount within 30 days. Failure to pay within 30 days will result in the original fine amount of $11,250 being reinstated. Next case.
Next case on section 10.5 of the agenda, case 9501. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9501. Property owner Yesium 5401 LSC, site address 25th Court, Pembroke Park, Florida. A notice of hearing to abate fine was requested May 19, 2025. It is the town's motion to reduce the fine of $108,500 to $16,275, and the property owner is in agreement.
And that was 180,500.
108,500.
Okay, 108. Thank you. Case number 9501, property located at 5401 Southwest 25 Court. Anyone here on this case, seeing and hearing no one come forward? This is an abatement of fine from 108,500 based on the testimony and evidence presented, along with the agreement of the parties. The mitigated amount of 108,500. I'm sorry, the fine amount of $108,500 is abated down to $16,275. The respondent is ordered to pay that amount within 30 days. Failure to pay this amount will result in the original amount of $108,500 being reinstated. Next case.
That concludes all my cases.
Motion to adjourn?
Yes.